to see you.
Hi Hannah, hi everyone.
Just waiting to see if everybody's here. I want to start. Oh, getting a little bit ahead of myself. Fabulous. Can you hear me all right, Jay?
Yeah.
Fabulous. I think we might have everybody in that we were expecting, so that's good. So yeah, if that's all right with you guys, I think we're all right to get going. Very prompt.
Great. Okay. Well, thank you. Right. So I'll just introduce the session. So thank you, Steve and Hannah, for taking us through this session. For those of you that don't know me, I'm Jay Bhayani. I'm Managing Director at Bhayani HR and Employment Law, and we're a niche law firm specialising in all aspects of HR and employment law. We work with lots of charity sector and not-for-profit clients, and we started the Charity Leaders Forum a while back, and we think it's a really good idea to try and bring people together with topics that are trending within the sector and that we think you might find useful. So to date, we've done something on equality and diversity and how you diversify your charity board. We had a session on Let's Talk Trustees, so all about trustees and governance and what's expected of trustees, sometimes quite in quite challenging circumstances. And then the last one we did was about ChatGPT and how you can best use the very, very fast-moving landscape that we're living in for the benefit of your organisation. And we'd love to know what sorts of topics you're interested in hearing about in the future. So when we send feedback, it would be really useful if you could maybe let us know what sort of things you want, how you feel about online sessions like this as opposed to face-to-face, because we do like face-to-face, but it then limits our audience a little bit. And we've got people joining us from all over these days. So the next topic, I think we haven't put it on here because we haven't got a date, but the next topic is going to be about charities facing financial difficulties, because that's one of the things that we're seeing quite a bit of, and we're going to collaborate with Deborah Lockwood at Leonard Curtis. And there are lots of ways in which charities, if they get ahead of it, can really help themselves to manage financial constraints. And sometimes charity mergers, which is our topic of today, is driven by financial issues. But we're going to have a session specifically what sorts of things you can put in to manage financial difficulties. So we'll kick off the session then on charity mergers, and Steve Chu, who I'm sure many of you will know, is going to take us through the session talking about the drivers for charity mergers and how you deliver a merger using the benefit of his experience. So thanks for that, Steve. And then after Steve, we've got Hannah, who's an employment lawyer at our firm, and she's going to talk about the very, very complex and sometimes a bit dull area around Tupe, but that's what we would be dealing with in a merger. We would be dealing with the transfer of employees, and it's a really high risk area of law. So we thought we'd do a little whistle stop tour, which Hannah's going to take you through. But if anyone needs anything more specific or bespoke, then follow up afterwards, because it's really not the kind of thing that you can do without some guidance, because that's where a lot of the problems come when we've seen charity mergers. Okay, so I will let you crack on then, Steve, and you can ask questions as we're going through. If you put them on the chat box, that would be great. We'll try and collate them at the end, and hopefully I'm at the end to answer some questions. Okay.
Thanks very much, Jay. Good afternoon, everybody. So yeah, I'll just be taking you through a few slides, probably for the next 25 minutes, just on the background to charity mergers and how to go about looking to deliver one. So if we go on to the next slide, just about, if we go on to the next slide, that'd be great.
Sorry, I am trying, Steve.
Okay.
There
No
you
worries.
go. My apologies.
So yeah, I'm going to take you through a bit of background, some of the key drivers for merger, some of the barriers which we do see, a little bit about federated charity networks, because I know that at least a couple of the people who are joining today are part of federations, and then a bit of project management delivering a merger. And I'll just leave you with a few sort of practical suggestions if you're thinking about looking to pursue one in the near future. So just a bit about me. I've been a freelance charity consultant since last April. And in that time, I've worked on 2 or 3 merger due diligence projects, which are now going through. I also recently completed a master's in charity accounting and financial management, and my final dissertation was on charity mergers. So some of the things I'm going to be presenting to you today are directly from that research I carried out over last summer. I'm also a current trustee at Western Park Cancer Charity and an almshouses just off Hunters Bar roundabout. And previously, some of you may know, I was chief executive at Age UK Sheffield for 7 years. So first of all, bit of background. And so mergers can be a bit of a Marmite topic within the charity sector. Some people who just think it's not what charities should be doing. Quotes from some publications: it's a scandalous and distasteful thing for charities to be considering. But it really is a polarizing concept and a bit of a Marmite issue. But as Jay pointed out, partly for financial reasons, it's something that increasingly charities should be at least thinking about when they're planning their future strategy. So I think next we've got a bit of a couple of polls. So linked to that in terms of sort of mergers and how they're viewed within the sector, I've just got a quick poll to ask how many registered charities everyone thinks there are in England and Wales at the moment. Just give you a few more seconds to cast your votes on that, and then if you hold your answers, I'm going to go on to a second poll, which if we can move on to the next poll when we're ready, Alice, which is going to be about how many mergers you think were registered in 2022 to 23. And then Alice, when you think everyone's votes are in, we'll move on to the next slide.
I think there's some chopping and changing.
It's fine. We can move on, and the answers will become clear very soon. So, I mean, the background and the reason why I sort of set up those thoughts is that some of the we'll come back to that poll. Keep going. Yeah. So the background is that there are, for some people, believe there are too many charities with similar objectives, and that they're duplicating each other's work. And by doing that, they're competing for diminishing resources. And so people who say there should be more charity mergers are basically saying it's tough enough to be in the charity sector without competing with a load of other charities who've got similar objects and competing for the same money. So the answer to the first poll, there are currently just under 170,000 charities registered in England and Wales. And that number keeps going up, even though the sector does get more and more difficult. The number of registered charities does keep going up. And in terms of, if we move on, the number of mergers registered, the correct answer was 48. So a really, really low number. So that number comes from a publication called the Good Merger Index, which is published by a consultancy called Eastside People. They do quite a lot of analysis of mergers from various sources. They've been publishing the Good Merger Index for the last 10 years. It is available online. And they only found 48 mergers within the financial year 2022 to 23. That's the lowest number they found in the 10 years they've been doing the Good Merger Index. Although they do believe that part of that was a lag from the COVID period, because obviously merger discussions, merger exploration can take months or years in the making. And they are starting to see increased demand for mergers now that will probably go through over the next few months or maybe next year. So that's a bit of background. One of the other complications in terms of background for charity mergers is that in most businesses, it's all about the bottom line. So, for-profit companies merge all the time just to be financially better off. In charities, we've got much more, many more considerations around why we exist other than to make money. And we've got our beneficiaries, obviously, are primary. But we've also got trustees, staff, volunteers who are really committed to our cause and the nature of the organisation. And also we've got funders who have got a big stake in the future of our charity. So if any charities were thinking about merging, there are a whole range of additional stakeholders to consider. But there are a number of drivers for merger. And so I'm just going to take you through a few groups of drivers that I found in my research. So the first group are finance-related reasons, as mentioned by Jay. And so some of the finance reasons for mergers are charities concerned about their ongoing viability, potentially live in a hand-to-mouth existence. Others maybe have a less of a short-term issue, but know they need to make savings on an ongoing basis, or potentially think that by coming together, they've got an opportunity to generate increased income. So a group of finance-related reasons why charities decide to merge. In terms of strategic benefit, some look at potentially long-term benefit in terms of their beneficiary impact and the range of services or service quality that they can provide to their beneficiaries, feel that maybe they can expand their services, maybe expand to different beneficiary groups. So potentially, there's comings together to improve service delivery or respond to a new opportunity, new funding opportunity. And then some other drivers for merger relate to internal capacity. So this is slightly different from finance-related reasons in that either charities feel that they're just too busy or too exhausted to provide good quality frontline services, or perhaps they've not got enough supervisory support, or they're struggling really to provide all the back office infrastructure they need, whether that be finance, HR, service quality, just can't afford all the back office infrastructure they need. There were some internal capacity issues around jack of all trades leaders. We know that particularly within small charities, the chief exec or the general manager has to do virtually everything, and that can lead to real exhaustion and not enough ability to focus on the future and strategy. And also some charities reported they've not got enough trustees or not enough quality on their board of trustees to provide good governance. And then a final set of merger drivers around the external environment around charities, either pressure from funders who want charities to merge or at least be more sustainable. Maybe external quality inspections, maybe an inspector, either an ISO 9001 or your council commissioner has come in and said, you're not really delivering as you should be. And so that can be one set of reasons for merging. And others more positively feel that by coming together, they can have better engagement, better influence on policymakers to produce better policy and better outcomes for their beneficiaries. So there's some of the drivers that people set out for why they want to merge, and maybe some of those reasons resonate with some of you today, and a reason why you've joined in today. In terms of the barriers, there are some regularly cited barriers to merger, particularly in the charity sector. Often they're about senior leadership, chief execs and trustees who either want to retain power and control of their charity. Maybe there's some fear there about what the future holds for their charity if they let go of that control, or maybe some individual fear about what it will mean for them as an individual, particularly in terms of the chief executive and even loss of the job or loss of face. There's a bit of founder syndrome that goes on, so not necessarily always to do with founders, but those intense feelings of real ownership and not wanting to let go, and sometimes a lack of information. So sometimes where two charities do get involved in merger discussions, there's a perception that one or other charity is withholding information, and it leads the other charity just to lose confidence and lose trust and just walk away. There are also some perceived risks about getting involved in mergers, and that's quite an interesting one, because you can get really risk averse about, merging seems a really big thing and seems a really risky approach. What's not often thought about is what are the risks of staying as we are, and it can be, running a small charity can be really exhausting, and looking 3 to 5 years ahead is just trying to stay on the treadmill as we are. Those risks sometimes get overlooked. There are some historical factors. Sometimes, if two charities are thinking about merging but know almost too much about each other, there's some historical issues that have gone on. They can put people off, and also staff and volunteers are understandably concerned about any talk of merging and what that might mean for them in terms of the charity. But on the flip side, there's a real opportunity to overcome some of the barriers, and particularly these relate to chief execs and trustees taking a leadership approach to it. So Alice, if you're able to flip over, some of those are around individual leadership, and what I found in the research is that actually the personal drive and resilience of particularly a chief exec can really help to push through a merger, particularly when it might be at risk of getting stuck in the mud. Also, trustee champions who really believe that it's the right thing to do for their charity and really help to drive it forward in terms of the board can really help to overcome barriers. And also, more operationally, found that leaders who've not been involved in mergers before get really risk averse because they've not really got that experience, whereas people who've done mergers either in previous charities or in previous consultancy work, they've got a lot more confidence of learning from their experience, and they help to unblock issues as and when they arise. There's also a real area around shared leadership, and so existing trustee boards get really focused on their existing charities, their existing beneficiaries, perceived risks around them, whereas actually coming together as potential shared boards or groups of trustees who are looking to the future can have that focus on, well, what might the future look like? What might the impact be for our beneficiaries? How might we be able to resolve some of the issues we've got in our existing charities, and take a bit more of an entrepreneurial approach to looking at actually how we could develop our charities for a shared future. And then a couple more issues in terms of overcoming the barriers. One key barrier is around perceptions of loss of control, and actually an understanding that individual charity boards can have control in the process of coming together, and also a real positive overcoming the barriers for merger is in terms of just being at the right place at the right time. So discussions can be going on for months and years, but actually at a time when, particularly when a chair decides to leave, or a chief exec gives advance notice that they're planning to leave, or potentially you've got a year's notice that a contract is going to end, they can be real stimulators for, right, now's the time when we really need to focus in on, let's have some really serious discussions as to, is this now the right time? And that right place, right time issue can provide a bit of an impetus and a bit of a deadline to say, right, if we're ever going to do it, now's the time, let's get on with it. I've just put together a couple of slides on federated networks, because I know there are a couple of people from federated networks. So just to be clear, federated networks are where there is a national charity, also lots of local individual charities. So I came from one in terms of Age UK, where all the local Age UKs are independent charities and independent of the national network. And there are a range of others, you know, RSPCAs, Minds, MenCaps, where all the local charities are different. And certainly some of my interest in mergers came from my view that there were too many local Age UKs. There are over 130 local Age UKs across the country, all with their own chief execs, finance teams, policies and procedures, etc., etc. And I focused my research on those federated networks, and there were some additional drivers for mergers in those networks in terms of strategy. So there were issues around geographical footprints, where sort of the local charities maybe came into conflict over shared borders, or maybe where a local charity provided different services from their neighbour, and there was whole issues over beneficiary impact and consistency of service delivery. And also in terms of back office capacity, where you've got federated charities where there's lots and lots of small back offices, could they be more efficient and effective by coming together and sharing some of those back offices? And also we're in terms of the external environment, particularly where lots of local charities within the same federated networks are applying to grants from the same organisations. We know that some of those funders are going to the national charity and say, what's going on here? We've got dozens of applications all from the same network. Can't you get together? And also, as we've seen, particularly in the health sector, commissioner footprints change, and we've definitely seen some evidence of local charities seeking to merge to keep track with the health footprints to be better placed to win health funding. And also, secondly, within federated networks, there is the third stakeholder, which is the national charity, which can be really beneficial in providing national toolkits, staff support, maybe money to support the processes. They can also provide a bit of an impetus to sort of encourage mergers within the networks, but also they can be viewed negatively in that, you know, local charities are fiercely independent, and if their national charity tells them to do something, then they definitely won't do it. So, you know, that the national charity influence can be viewed positively or negatively. But really, the important factor there within those federated networks is those relationships between local to local charities and the local charity to the national charity. So there's the background drivers and barriers. I'm just going to take you through now practically the sample merger process. It'll be different for everyone who's considering a merger, but here are some of the key steps to go through in terms of thinking about merger, bit of exploration about merger partners, developing the business case, implementing it, and then really importantly, cultural integration of the charities into the future. So first of all, thinking about mergers, I mean, this should really be an ongoing, maybe annual process where charities are looking at, what have we achieved over the past year? How have we delivered for our beneficiaries? How can we be most effective in delivering for our beneficiaries in the future? And in terms of thinking about, when you write your annual report potentially, or your strategy or business plan for the next year, is now time to think about whether we could achieve our charitable object better by collaborating with another organisation. And one of the things I think is that by thinking it about in that way, as more of an ongoing process, it becomes a bit less threatening than what it is currently in the charity sector as, this terrible thing that we've got to think about when things are going, badly for us. Actually, if it becomes more of an annual thought process, it becomes a bit less threatening, a bit more normal behaviour. In terms of choosing a merger partner, there's a whole process that I would go through with organisations I'm supporting in terms of looking at how aligned are charities in terms of their strategy. Have you got similar aims? Are your governance processes fit for purpose in terms of coming together? Looking at operations in terms of your organisational structures, how you deliver your services, some of the issues around just staff terms and conditions. So if you were to try to bring staff teams together, are your terms and conditions so different that it will be really difficult or expensive to come together? Or are there opportunities through gaps in structures to actually make a lot of savings by coming together? And Hannah will go on to talk about sort of Tupe processes and how to do that. Other areas in terms of operations of making savings potentially are on the back office in terms of perhaps IT costs, finance costs, and areas where you can potentially make savings by coming together, but maybe with some upfront costs in doing that. The market review, what I would look at there is what are all the key income sources of the merger partners, and how can perhaps they be enhanced by coming together. So ways in which they could be enhanced is if two charities are specialists in different service delivery, can you both expand your service delivery into new geographical areas or new beneficiary groups so that you can merge as a bigger charity, you can grow, as a merged charity. There are obviously risks to that as well. So for example, if you're two charities who both survive mostly on grant aid, and you've got grants from similar organisations or the same organisations, is there a chance you'll lose some of that grant income by coming together? So there's a whole exploration there around, checking your income sources and making sure that you're going to be net winners from merging and not net losers. And then finally, what some would regard as the biggest area in terms of choosing a merger partner is looking at your finances, both in terms of your general performance, on a year-on-year basis, your balance sheet, have you got assets rather than liabilities that you're taking over, and also a really deep understanding of how your charities work on a service delivery by service delivery area basis. So in many charities, there'll be some areas where you're making surpluses because you're doing quite well on your contracts, but there are other areas maybe you're taking decisions to subsidise some services. And if two charities are looking to combine, you really need to have deep understanding of each other's organisations to make sure you're not committing to taking on services that are just going to be loss-making year on year. So there's a real deep financial review that needs to take place to make sure that you're not straddling yourself with costs that are really going to sort of hamper you in years to come. Once you've gone through those processes and you come to a stage where 2 or more charities are thinking, yes, actually, we think it's a good idea for us to look more into merging, and we need to decide how we are legally going to do that. There's a whole process to look at, what are the merger options to come together. So some of these are illustrated on the next slide. So this is also from the Good Merger Index. So quite a lot of people think of mergers as, right, we'll close down our existing charities and we'll set up our new charity, which is the first one there, the merger, number one in that graphic. That is actually not the common way of doing it. So there are a few other sort of models, legal governance models for how that can be taken forward as a takeover, a subsidiary model, a group structure, or just swapping services or assets. So I think the final poll is just to ask which of these 5 you believe are the most common form of charity merger. So Alice, if we can just start that poll, that's great. Okay, so hopefully you've had a chance to do that. I'm not sure what has anyone got access to reading out the results of that poll?
I can share the results. Bear with me. I've just got a couple more people to pop an answer in.
Thanks, Hannah. So thanks. I don't know if everyone can see that, but 50% said takeover, 30% said merger, and there was 10% for subsidiary and 10% for swapping services or assets. So the actual answer is that by far takeover is the most usual route to complete a formal merger. I think in last year's Good Merger Index, 90% of those 48 mergers were actually legal takeovers. There are a couple of reasons for that. One is in terms of cost. It's much more cost effective because generally you only have legal costs from closing down one charity and integrating them into the second charity. If you actually do option 1 on this slide, the merger, you've got an additional set of legal costs. So you've got costs from closing down both existing charities, and then you've got a third set of costs from setting up a new charity. The other reason, which is really important, is trading history. So particularly if you're bidding for contracts or bidding for grants, normally those commissioners or those grant funders want to see your financial history, your trading history. And if you're setting yourself up as a complete new organization, you don't have any of that trading history. And so that's why it's very common, or much more common, that the legal process is actually a takeover. So one charity closes, transfers its assets into another charity, and then you've still got all that trading history to present to grant funders and commissioners. Now, culturally, there are ways to make that feel much more like a merger. So you might change the name, you might have a whole reset in terms of the charity aims, objectives, strategies, building your vision, mission and values. But the legal process is a takeover for those reasons. So just to go on to the next slide, the business case, once you've chosen your option, then you can put together a business case, which is based around looking at all the startup costs of merger. So that will be your legal costs, HR costs, which we'll come on to as a combination of specialist input from companies such as Bhayani HR and Employment Law, also potential redundancy costs. And then you'll also have things like project management costs, because actually it's very difficult to deliver a merger on top of existing staff stay jobs. You probably need some sort of project management resource to help you through the process. But hopefully there will be long-term savings to be made. And so the business case will look at comparing those startup costs to the long-term savings or benefits. And hopefully, if you're recovering all your startup costs within 2 or 3 years, then generally it's probably financially a sound decision. In terms of implementation, there's a whole load of project management stuff to do around individual boards' due diligence and decision-making processes. So the legacy trustees need to make sure they're taking decisions in the best interests of their beneficiaries. There's some legal and governance arrangements around the new board, creating the shadow board and the new charity, and the governance process around creating the new charity. Obviously, internal, external communications, which can be overlooked, but can be really important, particularly in terms of engaging with staff and volunteers, particularly around HR processes, which are there on the bottom. And then also in terms of strategy, finance, developing the whole strategy and business plan for the new charity, and pulling together the accounts and the business plan objectives. And then finally, the thing that is really overlooked, and so it is pretty much my last slide, but it's probably the most important slide, is the cultural integration. There's a bit of my research which found that more than 50% of mergers actually end up failing. And actually the reason that the majority of those failures happen is that companies or charities do not become properly integrated. So people look at the completion of the legal processes, that's the finishing line, we've done it, we've merged, great. But then they carry on operating as two independent organisations, don't bring together the staff teams, don't bring together processes and procedures or back office systems. And it's really, really important over the coming months and years after the merger, you really focus on that initial impact, making sure that staff and volunteers are aware they're working for a new organisation now, really bringing everyone together, staff and trustees and volunteers, to really reset those vision, mission and values, develop the strategy for the new charity, and really making that stick in terms of, on an ongoing basis through the services you deliver, through HR processes, through recruitment processes, through performance reviews, making those new vision, mission and values really stick in terms of how you're working together as a new charity. So my final slide, just a few practical suggestions. If you are thinking about merger as potentially something that you might want to get involved in over the next few months and years for your charity, one is to really focus on your beneficiary outcomes over the preservation of your existing entity. A lot of trustees and senior managers get focused on your existing charity, your existing beneficiaries, your existing services, your existing name, and actually, as long as you can continue to improve the impact for your beneficiaries, that should be the focus over the name of your organisation. Maybe try to carry out an annual review of the effectiveness of your charity to make it more of an ongoing process rather than something that you come to just when you're coming into difficulties. Use opportune moments. So if you know that you are planning to leave or retire in the next 18 months, or your chair's planning to leave, trying to have those honest conversations to set up some future planning as to, is now the time to look at a different structure for an organisation, or to talk to potential counterparts in other organisations about how could we work together more closely to solve some of the common issues that we've got. Maybe a bit of leader training and development. So you're here today in terms of just building up a bit of confidence in knowing what some of the key issues to face are if you are thinking about merging in the future. And also the use of specialist support, such as Bhayani HR and Employment Law, for things like HR processes, which it's really, really important to do right to make sure that Tupe processes happen in the right way. That's me. I'm going to hand over to Hannah now. Hope that was useful for you.
Fantastic. Thank you ever so much, Steve. That was really, really useful. I do think we had one question though while she was speaking. If you wouldn't mind popping back on your mic, hopefully it's something that you will be able to answer. If anyone else has any questions, do just pop them in the chat box. But the question was, is a federated network similar to a franchise?
It's similar. I mean, so if you're not familiar with a federated network, it could be thought of as a franchise. I think the key difference is that in a franchise, you're almost buying into a brand with normally a set of rules that you have to follow. So it's a legal agreement normally to follow a set of rules that is laid down by a head organisation. Whereas within a federated network, all the existing entities are independent, and there's normally a set of rules as to how the local organisations and the national organisation can work together. So similar, but there's a bit more local independence normally in a federated network.
Brilliant. Thank you ever so much. Hopefully that answered that question. Fabulous. So yes, I think you've covered loads there, Steve. So thank you very much. That was really, really useful. Hopefully I'm able to add a few more a few more points to what you've discussed. Obviously there is Steve's email there if anybody has any direct questions and they would like to get in touch with him directly. I think we'll also be sending the slides out if people would like to see them as well, so you can obviously get that information from there as well. But yes, so basically I'm here with Steve to discuss how it is that we can assist you through these processes. If it gets to the point where you have decided that a merger, any one of those different models that was discussed, is something that your charity needs to undertake or would like to undertake, then yes, you are going to likely need support through that process. What we can do is a number of different aspects that Steve touched on in his presentation, not just the due diligence to transfer those employees over, but also throughout that integration. So we like to call it the employee journey or the life cycle from when they get brought in initially, ensuring that all the policies are as they should be, and aligning those values and keeping that employee engagement as well, which Steve highlighted is, a really important aspect. It's not just over at the point the transfer takes place or the merger completes. It's ensuring that throughout those employees remaining with you, that they're all going to work in harmony, or as harmonious as we can manage. I know that's often not as straightforward, and that's why we've got a job in dealing with those things, because we can take it all the way through to the exiting of that individual, whether that be voluntary or otherwise. Equally, we also have a training arm, in that if there is any further training that you believe would be necessary, either prior to a merger or afterwards, that you think would be beneficial, then do please get in touch, because hopefully that is something that we would be able to offer and support you with as well. Obviously, you're all into training if you've come on here today and you see the benefit of any information. Knowledge is power, isn't it? So any further information that you can obtain should hopefully set you and your charity up in a really good space. So yeah, all those different issues, what we will be focusing on today, that's just a few of our accreditations for anybody that doesn't work with us. I think I've seen quite a few of our clients that are on here today, so that's really good to see, or people that we have already worked with. But if there is anybody new, that's just a little bit about us as a firm. Yes, so what we're focusing on today is the Tupe transfer process, which, as Jay alluded to at the beginning, can be a little bit dry. Hopefully, I'll keep you awake long enough and engaged so that we can all get some really good information out of it today. But I just wanted to start us off with a bit of a poll, just to see if anybody really knows what we mean when we say Tupe. It does stand for something. So if we can all take a look at the poll that should be in front of you at the moment. What do we think TUPE stands for? I think some people call it Tupe. There's lots of different meanings. I remember when I was at university, it was a toupee. Somebody had put a toupee on. generally speaking. We've got a good few answers coming in. Don't know if anyone can see the red herring option. Don't think anyone's gone for that yet. But no, generally speaking, I think we've got 80% of people have got that right. It is the transfer of undertakings, protection of employment rights. So I will end that poll. And essentially it is for transferring employees. So as we say, the transfer of undertakings, protection of employment in brackets, regulations 2006. Now you don't need to be concerned and remember that acronym. That is just to see if any of you are familiar with it previously. But nobody's going to test you on that if you do want to go through a Tupe transfer, so don't worry. What this essentially means is that when there is what we call a relevant transfer, so that's a transfer of business or an undertaking or part of a business, any transfer of what we refer to as an economic entity would often be caught under these regulations. Now, these regulations have certain requirements, and hopefully we're going to go through those today so that we all understand what we mean by that. But it essentially protects employees when a business or a service changes hands, to ensure that they enjoy the same contractual rights as before and they maintain their continuity of service. So this is all about your employees and how you move them through this part of the merger. So it introduced three main concepts, really. It is a piece of European legislation, but within the UK, it introduced three main concepts. So what we call the automatic transfer principle. So employees transfer and inherit all their rights and their obligations. You essentially step into the shoes of the previous employer when you obtain employees in this way. There is a protection against dismissal in connection with a Tupe transfer. Now, that's sometimes a bit scary for people and they think, I can never dismiss this person ever. That's not what that means. It is purely if the dismissal is in connection with that transfer that's taken place. And there is also an obligation to inform and consult with representatives of those affected employees. There has been a very recent change to that concept, and we will touch on that later. But those are the three main concepts of the Tupe regulations. So when does it apply? So it applies to, as I said before, a relevant transfer. So that is either, as I say, the transfer of a whole business. It might be part of a business. It might be a department. It might be one locality. Any form of economic entity that is retaining its identity following the transfer. So if you provide services in one way and now you'll no longer be providing those services, but somebody else will, and those services retain their identity, that is likely to amount to a Tupe transfer for those employees that are fulfilling that service. Service provision changes, that it's not as straightforward as, in real life, it's not as straightforward as, oh, brilliant, these two people are transferring and there's no overlap and they don't do any other job. So it can be sometimes quite difficult to identify when a Tupe applies. And if you do have any concerns in relation to that, I would just recommend that you get specific advice. It is something, it's part of my job that I review changes of service provisions to see whether a Tupe transfer is likely to apply or not, and therefore what you need to do in those circumstances. So don't be concerned if you don't see it straight away. But generally speaking, any economic entity that retains its identity following the transfer, or generally a service provision change. So that automatic transfer principle that we touched on. So those contracts of employment of those employees that are employed by who we call the transferor, so that's employer number one, and they're moving to employer number two, they will automatically be considered to be transferring. So they're not necessarily given a choice. They are, obviously, to a degree. If somebody does not want to transfer, then they have the right to object to that and not become employees of employer number two. Instead, their contract of employment would essentially terminate. And there would be no dismissal. It would purely be that they choose not to transfer, and therefore, because their role at their current employer is no longer there anymore and they don't want to continue in that role, that is the end of their employment. So to a degree, they do have a choice, but really if people are wanting to to stay in their jobs, there is that automatic principle. So they would go with their work and transfer to their new employer. And because there is that automatic transfer principle, there is those protections that mean they can't then, be just shoved into a new employer and told, right, we're going to change all your hours, we're going to reduce your pay, we're going to remove that additional sick pay that you have the benefit of. The reason the regulations are in place is to protect from things like that. So changing terms of employment. So that transferring employee will transfer on their existing terms of employment. There are only very limited circumstances by which you can change those terms. So I think, if this has ever happened to anybody before on here today, I'm sure you'll understand sometimes the frustration of, oh gosh, they're coming in on all these different terms and that's just not something we've ever done before. And I've got current existing employees that are going to say, well, hang on a minute, we're doing the same thing, and they have a higher entitlement to holiday pay or sick pay. And it can cause frictions. And I think that's one of the main things that Steve touched upon in his presentation, that integration, general day-to-day working can be quite difficult. Now, of course, those terms and conditions that those employees are transferring on are confidential to them. You wouldn't be sharing them with anybody, but there's nothing to say that, they may not speak amongst themselves. There's no obligation for you to increase or change your current existing employees' terms. You just have to maintain the terms that the transferring employees are transferred on. Now, of course, as I say, that is to an extent, and there needs to be what we call an ETO reason for that transfer. So that would be an economic, technical, or organisational reason. Now, I've had many examples put to me of course, that's an economic reason, or of course, that's an organisational reason. And it is a little bit stricter in terms of what we can and cannot change. The general rule is, ideally, we don't change anything. We can change, for example, the payday in some circumstances, because it can be very, very difficult. If you've got different employees from different original contracts, we're paying some on the 1st, we're paying some on the 15th, we're paying some on the 28th. Just an administrative nightmare, really. So things like that, there are certainly ways that they can be changed. But what we can't do is vary the terms as a direct result of that transfer. So if the sole or principal reason for the change is the transfer itself. So that's just something that we need to bear in mind when going through these types of mergers. And that third principle, the protection against dismissal. So Tupe does provide enhanced protection against dismissal, and it is over and above the general unfair dismissal entitlement. So if any of my clients, hopefully you are well aware that there is, generally speaking, a qualifying period for somebody to pursue a claim of unfair dismissal, and they must have been employed for at least 2 years continuous service. This protection is for anybody that has been transferred over. You do not need that qualifying period of service. So it can open the door. Dismissals will be considered automatically unfair if the sole or principal reason for the dismissal is the transfer itself. However, if the reason is what we've referred to before as the ETO reason, it could still just be potentially unfair. And as I say, that's why we need to be really careful with what we are identifying as an economic, technical, or organisational reason for any change. Resignations in response to a repudiatory breach of contract or substantial change in terms, if the employee has suffered a material detriment, can be deemed a dismissal, and that enhanced protection can also apply. So if you change all the terms and somebody puts their notice in and wants to pursue a claim of constructive dismissal, it could still fall under similar regulations. So generally speaking, this is why we identify Tupe transfers as a high risk or complex area of law that we would advise you get specific advice in relation to before we start trying to change or harmonise terms of any moving employees, whether they're your employees that you're sending off elsewhere, whether it's two businesses merging as one, whether there's a takeover, however that is set up. If employees are going to have a different name on their payslip of who's paying them, this is certainly a risk that you would need specific advice on. That obligation to inform and consult. So this is a a joint obligation on what we from the transferor and the transferee, so employer number one or employer number two. They must, if appropriate, consult, but always inform any recognised trade union, or if there isn't any of those, elected employees' representatives in relation to what is happening. Now, I appreciate that it's not something in the very, very early stages that you will be considering sharing. And I think that's completely normal. What you do need to consider is any other time restrictions you have in when you have to be sharing this information. So I would just advise getting advice as soon as possible. As soon as this is tabled as a potential option, we need to know really how many employees are going to be transferring over, and when this is likely to take place, because then we can set a plan of action of, right, okay, you have an obligation here to inform and consult with this amount of employees or this many representatives, and these are the things that you need to tell them. So that will be different for every transfer, and the time restrictions can also differ. So it's just something that I think the earlier you get advice, the earlier you're set up with as much information as you can, the better you're going to be in terms of dealing with this. So there's not necessarily a duty to inform on every transfer, but as I say, it's going to be an as and when, so I would recommend that you get specific advice. I appreciate there is a lot of information on these slides, so I'm not necessarily going over every single bit of it, but as I say, you can obtain the slides from the feedback that we're going to be sending out, and I didn't want to put you to sleep with absolutely every piece of information you need to know about Tupe. It's just the key whistle-stop tours today. But what is important is that a failure to comply with these obligations to inform and consult can expose both employers to pay compensation equivalent up to 13 weeks uncapped pay. So, you know, if you're transferring 20, 30 employees, all of which could be entitled to 13 weeks pay compensation, that can really, really rock up. And if you are considering transfers and mergers as part of a cost saving exercise, this is just going to be completely defeating the object. So what I would recommend, as I say, is that we try and avoid that in any way that we can. And it's really, really simple to do, because informing and consulting employees is not a hugely onerous task that I think some people sometimes consider it to be. And as I say, that is a joint, and the employers can be jointly and severably liable for this. So this is obligations on both sides of that transfer. So those consultations, what do we do? How do we go about consultations for these things? So as I say, the obligation is on both sides to inform and consult, to inform them of whether they're affected in the first place. So, you know, this might be happening somewhere else within our organisation, but are you going to be affected by that? The Tupe regulations only require the transferor or transferee to consult with representatives of their own employees. So you don't necessarily need to consult with every single employee that may be transferring over. You can do an internal ballot, and it may be appropriate to just have one or two representatives who will then go back and feedback on what you've discussed in those consultation meetings. As I say, they don't have to be recognised trade unions. But if the transferor employs fewer than 10 employees, where there's no employee representatives in place, they may inform and consult with the employees directly. So that can, you know, kind of defeats the object if you've only got 4 or 5 employees. In terms of getting representatives, it can often just be quicker and easier to consult with them directly, and that is absolutely fine. So what is it information that we need to be supplying? So when you're consulting with them directly, you need to be informing them of what is going to happen, when it's going to happen, all those kind of questions they're probably going to have anyway. But as employer number one, if you are transferring employees through to another employer, so if you are maintaining your identity, or even if there is part of a takeover, so you as a business may not be maintaining your identity anymore, but you had them in the first place, they were your responsibility, you have an obligation to provide what we call employee liability information. This must be supplied not less than 28 days before the transfer, or in very special circumstances, if that's not reasonably possible, as soon as reasonably practicable thereafter. So basically a month before, if not sooner rather than later. Those special circumstances are likely to only be really where we didn't know where we were sending that information to, or if a transfer takes place at such short notice. I think generally speaking, if you're doing a merger as you should be and considering all the different options that you should be, you're going to have a lot more notice than 28 days. So this shouldn't necessarily be a problem. But that employee liability information is the age of each employee. So when I say the identity, I don't necessarily mean the specific name of that employee. It can be employee A, employee B, employee C. But the age of each employee, particulars about their employment, they work full-time, they work part-time, they work from home, or we have a flexible working request in place for them to work compressed hours, or whatever that is about their specific employment. Information as to any disciplinary procedure, any grievance procedure. So this person's on a final written warning. This person is on long-term sick, for example, all that kind of key information. Or any information on any collective agreement which will have effect after the transfer. So anything that, generally speaking, you as an employer would want to know. If you were getting new staff in, we would recommend that you feed to the new employer. Rates of pay, all those different types of things, any holidays that are booked, any holidays that have been accrued but taken. We actually, when we are supporting our clients through this process, we have quite an extensive spreadsheet of information that we would send and request is completed, so that you've got, you're completing your obligations with all the ELI information that you need to supply, but also if you're on the other side of that, you're getting as much information as you possibly can. Now, some of those things, obviously, they're not going to be all relevant for everybody, but it's usually better to have more information than you need than not enough. Because the key point is really whatever particulars of their employment they have, whatever rates of pay they're currently on, whatever benefits they're entitled to, they're going to be transferring with that information and they're going to maintain it. So that new employer needs to know what it is that they're being held to. So what must you give to those employee representatives? We touched on that briefly before, but generally speaking, the fact that the transfer is happening, the date or the proposed date of when it's going to take place. So, the employee themselves, they may not necessarily be changing location. Nothing might actually change in their day-to-day job. All it's going to change is the name on the payslip of who's going to be paying them. So they need to know that it's happening because they may not know otherwise, when it's going to happen and the reasons for it. Now, the reasons for it, within reason. You don't need to be sharing private board minutes and things like that, but people will be asking questions that they are entitled to answers for. If there are any changes, what those changes will be, and as I say, the ETO reason for that change. Those measures are part of those changes. So if you are changing somebody's payday, for example, they're going to need notice of that. They may have bills coming in and out of their account on certain days when they anticipate being paid, and there may need to be a little bit of a kind of layover period whereby it's not going to happen straight away, or we may advise that you take things kind of step by step, and move it ever so slightly so that they can get used to that change. As I say, each individual change as and when they occur may require specific advice on how that would be best handled. So don't worry if you think, oh, I don't know how I'm gonna break this to them. As I say, there'll also be that obligation to provide that ELI information, as we previously discussed, to allow the transferor to perform its obligation and give that relevant information. So it might be a case of cross information, right? What do we need to share with our employees? What do we need to share with you about our employees? And kind of a joint effort between both sides to see if we can integrate as we should be. So what are the common problem areas? There are quite a few common problem areas, but I thought I'd just touch on a few that we have come across and that you might be considering at the moment if this is something that's going to apply to you. So number one, they don't notify and consult affected employees of the transfer. So either they don't think they necessarily have to, or they think they can get away with not mentioning it. And because there may be a transfer whereby that employee hasn't had any actual changes at all, they think, oh, you know, it's not a big deal. They're going to carry on working. They're still going to be paid the same. Nothing is going to change for them. You still have to notify them that that change is happening, because that is the name of their employer. Who they are employed by has changed. And so if it is that straightforward and if it is that simple, then great. It's much, much easier to deal with. And you essentially just need to send them a letter in plenty of time setting out the proposed transfer and how it will affect them. So, you know, even the smallest details, it may be the pension provider has changed because you just work with a different pension provider. The contributions are going to be the same, but you still need to notify them, and it needs to be in writing. In terms of consulting with those affected employees, as I say, I know that can be a slightly more onerous task, and so it's much more likely that that doesn't take place. But that obligation is still there. And it arises at the point that we'll be changing anything, any known measure. So if a consultation is needed, then those representatives will need to be selected, should there be more than 10 employees. And that conversation can take place, those consultation meetings can happen. So it doesn't have to be, you know, war and peace on absolutely everything to do with their employment. It would be a case of, right, we need to meet with you, we need to discuss and consult on these potential measures that we're needing to take. This is what they are, this is when they're going to take place, this is how we believe it's going to affect you. Do you have any questions? Do you need to ask me what concerns you have? And hopefully that is something that between both employers, you're going to be able to get answers to those questions. Problem number 2, employers try to impose their own contracts or change the employee's terms and conditions after the transfer. So the employee has never been notified that any measures are going to take place. They've transferred over, it's all fine. Second week they're there, right, okay, these terms are not going to work for us. This is what we're going to do instead. There you go. There may not have been any written contracts initially. So the employee says, well, I've got no evidence that this is something I was entitled to, but, you know, I've always been paid at full rate for sick pay, and now I've come off sick and dropped it to SSP. That can be a problem. And just because there are no written contracts in place doesn't mean that they can just change those terms. There is something called an implied term, whereby if somebody's been working under that specific term and received that benefit or whatever that may be for a set period of time, then that's likely to be something that they're going to transfer over with and remain entitled to. And it can be a breach of the Tupe regulations. And if you are that employer, it is much, much more likely that there is going to be a claim coming your way in the employment tribunal. It is a high risk thing to do, as I say, to change those terms after the transfer has taken place. So what we really want to get on top of is, prior to the transfer, bottoming out what those terms are and whether those changes do need to happen for those ETO reasons, economic, technical or organisational reason. And therefore, at that point, we can have consultation meetings, we can really get to the bottom of what these changes need to be, and we're not going to be in a position whereby we're imposing new terms and conditions after the transfer and risking claims being made against us in the employment tribunal. As I say, there are changes that can take place for economic, technical or organisational reasons, but it is subject to interpretation from the tribunal. They're not as broad, as I say, as people may like or envision them to be. So ultimately, I would recommend that you seek legal advice if you're going to be making any changes. Employers don't honour continuity of service after a Tupe transfer. So yeah, it is very often that we get, oh yeah, well, they've only been with me 3 weeks. They don't give us the full story, where actually, you know, they were with their previous employer for 4 years, they've transferred over, and that continuity of service is maintained. So anybody coming through to you, they may be a brand new employee to you, but they're not necessarily a brand new employee, full stop. Oh, just skipped a bit there. And therefore, they do come with that continued service, and therefore they've got that qualifying service to bring more claims than they would have otherwise. when you are looking at potentially drafting up their current contract with you and making sure all the paperwork with you is up to date, their start date is going to be the date that they started with their previous employer prior to the transfer. And it very well may be that actually it may have been the employer before that or the employer before that. If the service has transferred and has moved, that information, that length of service is going to pass with them. They're going to maintain it. And that's something, as I say, as part of the due diligence process, right before these mergers, you do need to be aware of. And it needs to be noted in their documentation as well, so everything's up to date. Forcing new employment contracts post-GP transfer, can, as I say, be a breach. And I hope that's something that is made very clear in this presentation, guys. We don't want any charities at risk of claims in the Employment Tribunal. Unfortunately, there has in recent years been a rise kind of overall, whether the charity or not. But of course, it can be incredibly costly for the charity sector if there are those types of claims. So these are really easy things that we can get sorted straight away to reduce that risk, hopefully to as little as possible. Dismissing those that they're not happy with after a GP transfer. So we've merged, or there's been a takeover, and we've got this new set of employees, and actually the way they've been working previously and maybe getting away with is not how you work, and it's really not working for you. And if it's immediately after that transfer, that is going to be, as I say, potentially an automatically unfair dismissal, regardless of their qualifying service, regardless of their length of service. And there is only one defence to that, and that's that the dismissal was for an ETO reason, so economic, technical, or organisational. Dismissing anybody, irregardless of a transfer or not, I would recommend that you seek specific legal advice about before doing so, because it can be incredibly high risk. But especially if there has just been a transfer of employees, you need to be aware that they have an automatic right. So it is even more high risk. And you need to follow the correct procedures in doing so. I'm not saying it's impossible, and it's certainly something that we can help you with if it is necessary. But do just bear in mind that these obligations, it is automatically unfair. Not fulfilling the obligation to provide employee liability information. So as we spoke about earlier, there is that obligation to provide that information. And unfortunately, I do have many clients that come to me and say, I've been asking and asking and asking for all this information, and they're just not providing it. It must be provided by that outgoing employer to the new employer. Firstly, so that, as I said before, the new employer can implement all those terms that new employee is coming over on. They can ensure that their rate of pay remains the same and that they're entitled to the benefits that they may have had before. That covers, as I say, some of the ELI information that is necessary. And should it not be provided, there can be steps taken in the Employment Tribunal for breach of the TUPE regulations in not providing that information. So you don't want to be that employer that I'm getting frustrated with that isn't providing that information, because it can be very, very damaging to your employees that are leaving you, but also to that new organisation that are inheriting them as well. So as I say, as you can see, this can be a very complex process, and whether you're employing people currently, whether they're transferring, whether they're leaving, taking advice as soon as you can is often in everybody's best interests. As I touched on earlier, there is a quick update. So from July this year, I think it's happening in the summer, as we said before, transfers involving fewer than 10 employees previously, you could consult with them directly. You did not need to appoint representatives. And from July, it is from the 1st, businesses with fewer than 50 employees who are transferring will be allowed to consult with employees directly as well. So you don't need to necessarily undertake a collective consultation as part of the transfer process. You can speak to them directly, which hopefully can, again, reduce that consultation time, which hopefully might result in more employers undertaking a full and proper consultation and reduce the risk of claims against them for failing to do that. it's all in an attempt to streamline this Tupe transfer process to make it as easy as possible, because as Steve mentioned in his presentation, there are lots of other things that you need to be considering and thinking about. And ideally, you want this element, the HR process, the legal due diligence of your employees, to be as streamlined and as straightforward as possible. Whilst the law isn't necessarily streamlined or straightforward, hopefully we can make it that way, and we can ensure that it's one less thing for you to worry about if we've got all the relevant information and we can be assisting in that. So as I said before, if there is any specific training that you think would be useful, pre-merger, post-merger, once you have all these new employees that you are going to be inheriting and hopefully living with harmoniously as you continue your great work, then these are all things that we can help train you up, help train your staff, your senior leadership team, the board. Anything in particular that isn't on there that you think actually it's something that would be really beneficial, let us know. I'm sure it's something that we would be able to help with. And our training lead, Ellie Hand, I'm sure some of you have worked with her in the past, is brilliant at putting together different training specs should they be necessary. I can see there is a question, so I will just make sure I've not missed anything. So do the terms and conditions have to remain the same for the duration of that Tupe person's employment, or can you eventually vary them? So there isn't necessarily anything in law that says, you know, after 2 years you can change their terms. But it would just be the same as any other employee. So anyone that you have on your current contracts, whether they've transferred or whether they haven't, if you want to vary the terms and the conditions of their employment, you cannot do so unilaterally. So what I mean by that is you can't just enforce the term. You can't just say, right, you're employed for 40 hours a week, I'm going to drop that to 30. It has to be something that both parties consent to. It's just the same as they can't say, right, I'm going to change my hours and enforce that upon you. So you can consult with them after the Tupe transfer process has taken place. If it's immediately afterwards, you've got a higher risk than you do with your current employees, because if they can point to that being only as a result of the transfer, they're entitled to more protection and they have enhanced protection. But I would say probably after 3 months, probably after 6 months of their employment, if you did want to begin consultations to look to change their terms and they are willing to consent to that, then that's absolutely fine. And you can get what we call a variation to contract drawn up. So that would just be a letter to say, these are the terms that you've agreed to change. Great. And that's part of your contract now. If they were to agree to them, and if they were not to consent to those change, it can become a lot more difficult. And I would recommend that you take specific advice as to what terms you're wanting to change and when you're wanting to do that. Lovely. Fabulous. I think we might be coming to the end. Oh, and we're Skills Bank approved. And we've been shouting it from the rooftop, so hopefully you all do know about it. But if you don't, then it's great news. We are Skills Bank approved now, which means there is a pot of funding that can provide bespoke, tailored training. And so do just, you know, inquire with us directly if you think that's something that you would benefit from. South Yorkshire businesses can get up to 40% off their training costs, which is just fantastic, because as we know, if we can save any money for you guys and still provide our incredible training, then why not? It's a no-brainer. And that's just a little bit about our fixed fee watertight plan, which I think a lot of you are aware of. So fantastic. These are just some of our upcoming events. In case you aren't aware, we have a HR Exchange meetup happening next week. That's very soon. And that is all about making emotional conversations easier in the workplace. So I'm sure if any of you are working in a specific HR position in your organisation, you'll be aware that those emotional conversations can get very difficult. Our HR Exchange meetup is a very relaxed setting of just getting HR professionals together, because we know a lot of you can work in isolation or just in a very, very small team. And it's, you know, it's really nice to have someone to bounce off your thoughts and ideas and, you know, is this happening to you too? Are all your employees as crazy as mine? That kind of conversation. So hopefully that can be really, really beneficial. That's happening, as I say, on the 19th of March. We've got our equality, diversity and unconscious bias training in April. which again, through Skills Bank, we can get funded places available. And then our Bhayani Business Social in June. I think hopefully that's going to be a summer social. We can be outside in the sunshine somewhere. And if any of you have been to those before, you know that they're a great evening. So do just let us know if you would like to attend. As I said, the feedback forms will be sent after the webinar. If anyone wants to request copies of the slides, then that's absolutely fine. And if you have enjoyed today's session, we would appreciate if you could take 2 minutes to leave us an online review. It'd be really greatly appreciated. But I do just want to say thank you to Steve for today. It was really, really helpful. And I think Jay's just popped back on. Thank you, Jay. Your introduction
thanks, Steve and Hannah. There was just one question, but I just had to leave the room, so I don't know if you picked that up, Hannah.
Yes, about terms and conditions.
Have you done that?
Yeah. Don't worry, we've covered that one.
Great. Right. Okay. Well, thank you very much to both of you, and I hope everyone's got something out of that. And we'll see you at the next one. And please do let us know what kind of topics you're interested in.
Fabulous. Thank you very much, guys.
Thanks. Bye.
Thanks. Bye-bye.